This is Mike Franklin, the property tax guy, and today we're going to talk about the two small claims assessment review cases I had down in the Binghamton County Courthouse for two cases I had for the town of Vestal. This is Broome County, and it's where they have the state courts for the 6th Judicial District, which is a 10-county area encompassing most of the southern tier and up into Madison County, Tompkins County, Delaware County, Steuben, Tioga. Anyway, pretty large area. And so I'm going to describe what transpired. I'd gone back and forth. I'd submitted a media request to be able to record these hearings, and I had to go back and forth with the administrative judge a number of times. And right off the cuff, he denied my request on behalf of the hearing officers. The hearing officers are essentially judges, and that's what judges are for, is to weigh the facts. But the administrative judge, Eugene Faughnan, I'll show you his picture shortly, he took it upon himself to make the determinations, and I suggest he didn't take the time to make proper determinations. He immediately denied me based on RPTL section 735, which says determination, not precedent, is how these cases are decided. And since there's no precedent, there's no need for a transcript. So it says no transcripts. So I have to help Mr. Faughnan with the roots of his words. Transcript, as in scribe, as in written. Transcript is a written translation of from another media, to writing. It's got nothing to do with video recording, and yet he denied me based on that. So that's what they always try to deny on. It's just, 735, denied. That's what they do. But it's got nothing to do with it. It just says that the small claims assessment review cases are decided based on determination. That's all it says. And so they're just trying to use some vagueness in the law to suit their own agenda. And I'm going to suggest that Eugene Faughnan's agenda was that he doesn't have time for SCAR and it's beneath him. He's making $220,000 a year, and it's his job to administer SCAR. But apparently, like I say, it's beneath him. He's, he does state Supreme Court cases, and that's what he does. These assessment matters are beneath him, and so that's why he didn't take the time to analyze this properly. And then he cited Section 131.1 C of the Rules of the Administrative Judge. And C says there are to be no transcripts of witness, or there are to be no recordings of witness testimony, which, as we all know, is not true. It happens all the time, and it contradicts 131.1A, where it says it's the policy of the unified court system to be open and transparent, so on and so forth. And then section 131.1D, of course, he doesn't mention these things. He just mentions C. 131D says that the intent of these rules are not to interfere with any pre-existing rights, such as the First Amendment. And so there is nothing in there. Apparently, it gives them room to decide whether or not they want to hear it or not. But to me, if they are to deny this, they'd have to come up with some reasonable, articulable time, place, and manner restrictions. So some logical explanation why it would not be appropriate. Like, for example, if you're protecting a rape victim or a child or something of that nature, or there's people who are subpoenaed that are against their will, that that they have rights too. But there is nothing in this particular case of that matter. The assessor has no expectation of privacy. The hearing officer has no expectation of privacy, and my client and myself, want to record it. So there's just, it's just nonsense, is what it is. And so he just says 131.1 and 735. And, I asked him to explain how they are relevant, and he refused to do so. It's just so because he said so, because he doesn't have time for this nonsense, even though he's being paid to do it, which was kind of interesting because the assessor had indicated that I was a fraud to one of my clients. And to me, a fraud is somebody who gets paid to do a job and doesn't do it. And so in this particular case, the assessor refused to talk about the case so we could discuss the condition, so that we could be on the same page as far as the condition, and he refused to do so, even though he's being paid to do so. And also, the assessor did not participate in the hearing. the town attorney had to do it for him. So the assessor was getting paid to attend these hearings, and he didn't do it. That's a fraud. The administrative judge, it's his job to administer small claims assessment review, but he can't be bothered. $220,000 he's being paid, and he can't be bothered. And to me, that's a form of fraud. It's arrogance is what it is, and he just can't be bothered. But anyway, but this is the courthouse that we had to go into, and I live north of Syracuse, about 15, 20 miles. And so I had to drive 90 miles each way. I had requested it be done via Zoom, but they refused because they didn't want me recording the Zoom session. So I had to drive down to Binghamton, and then the town attorney had to come from Vestal, and then you have a hearing officer. There was 2 different cases, so there's 2 hearing officers, and there were 3 court police in the courtroom, and I think there's another 3 more downstairs. So you had six police officers, and it looked like there was 2 cases going on in the entire building. It's just a monumental waste of money. It could have been done via Zoom, and so it's not their money. They don't care. But I tell you what, it's a pretty cool courthouse. It looks really big, but it really isn't. You've got all this facade here and this thing up here. It's all unusable space. It's actually a relatively small building, but it's a very substantial building. And they've renovated the interior, and the interior doesn't really match the exterior. It's kind of unfortunate. But they've got this cool Civil War monument out front where their regiments participated in Malvern Hill and Lookout Mountain, Tennessee, and I think the Wilderness and a bunch of others. Pretty cool stuff. But it's just a monumental waste of money. It should have been done via Zoom. The hearing officer had to wear a mask because he's concerned about COVID. I've never had COVID, but I'd prefer not to get it, and it was just completely unnecessary to expose everybody to that when it could have been done via Zoom. Just ridiculous. So let's move on and see what else I have to talk about here. Let's see. So what I was kind of pleased with was the first hearing officer seemed to understand what it is that I was talking about. Oh, one more thing about Judge Eugene Faughnan. He also claimed that I wasn't a bona fide member of the press. That was one of his rationale for denying me. And it's like, it's the government cannot regulate the press, and it's just kind of a constitution thing. And who is it for him to decide who is legitimate and who is not? And here's a Reporters Committee for Freedom of the Press. They have a definition, and basically, if you disseminate material, on a regular basis to the public, that makes you media. But the thing is that, in my opinion, you don't even need to do that. Every person in this country is a legitimate member of the media. Every person in this country contributes to the common knowledge. But so that was outrageous. But so here we are. So I'm going to talk about the first hearing officer, and I got the impression that he knew what I was talking about, and I got the impression that he was willing to be fair and reasonable about this thing. And so I felt pretty good about that. I hadn't experienced that. My previous hearing officer, I just didn't, the previous year, I just didn't think she had a clue. It was absolute chaos. I couldn't even get a word in edgewise because she was allowing the assessor to constantly interrupt me. And therefore, I had to start interrupting him, to try to make, and it was just absolute chaos. And so I had to describe to her how she might be able to control her own hearing. It was ridiculous. And apparently she was a family court attorney, and I just don't know how that qualifies her to value real estate. It's just ridiculous. But this guy seemed to know what he was talking about. His name is Stephen Ferry, and I felt comfortable. I feel comfortable leaving the decision in his hands. Because I felt that he was being fair and impartial, and I got the impression that he was hearing what it is that I was saying, and that's all I can ask for. and he's going to decide what it is that he decides. But one thing he did do is that the administrative judge did not do is he cited some case law as to why I would not be able to record, and it was the Courtroom Television Network versus the state of New York. And I haven't had an opportunity to read all of this, but what I've gathered from what I've read so far is that the TV channel can't just interject themselves into any scenario. There can be people whose rights need to be protected, and so that's what I gathered is that. But the administrative judge or this hearing officer is using this to suggest that I can't record these assessment hearings. Well, there's nobody to protect in these assessment hearings. But I'll get into this. I'll be reading this case in more detail, and I'll be looking into it to see if it's legitimate. But on its face, as the administrative judge likes to say, it makes absolutely no sense that an assessment hearing would not be able to be recorded. There's nothing more public than assessment matters. And I guess the only reason I could see why it would not be wanted to be recorded is because Judge Faughnan's assessment hasn't changed since 2006, and it's less than what he paid for it in 2006. So that would be one reason. And I guess another is that he doesn't want his hearing officers to be shown to the public that how it is that they respond. The public may not think that it's appropriate. And certainly last year's should have been recorded so people could see how that hearing officer, frankly, I just don't think she had any business being a hearing officer. She's just simply not qualified. I'm certain that she's more than competent in family law, but I don't think she knew anything about assessment matters. So we'll get into this. So it was very good of the hearing officer the administrative judge should have taken the time to send this to me so that I could analyze it and respond to it, but he couldn't be bothered. But I appreciate this hearing officer bringing this to my attention. But bringing it to my attention at the time of the trial of the hearing is really too late, because what am I going to do? Sit there and read the whole case, while they sit and wait? It's ridiculous. They should have sent this to me in response to my application, but they didn't bother to do it. And not only that, there's a checklist at 131.3. Of things that you need to do in response to an application for video recording, and the number one item is to interview the applicant, which no one ever did. They couldn't be bothered. The administrative judge Eugene Faughnan could not be bothered, even though he's paid $220,000 a year to do it. So it's an outrage, and frankly, when Eugene Faughnan says 735. Says you can't, no transcript. It just makes him look either incompetent or crooked. It just undermines the credibility of the court when he does that. It's outrageous. Let me see here. I won't get into I won't bore you with the details of the case, but basically what it was is that the here's a little definition of what I think comes down to Eugene Faughnan. He's a Luddite, a person who dislikes technology, especially technological devices that threaten existing jobs or interfere with personal privacy. That's Eugene Faughnan. He's a Luddite. But he's undermining the credibility of the court system by doing what it is that he just did. He couldn't be bothered to look into it, and it's just outrageous. Making this thing go into the court just unnecessarily costs the taxpayers money when it could have been handled by Zoom. It's just ridiculous. But they don't want it recorded. So we got to drive 90 miles for no reason. So anyway, back to the case. It was a really simple case, and it was all about the condition of the property. It was two very similar properties. Both of them had some significant acreage to them, and both of them were one was 31 years old and the other one was 36 years old. And so the argument was on condition. The assessor had defined in his assessment that it was in normal condition. And so I read the definition per the New York State Assessor's Manual to the hearing officers that it didn't meet the normal classification. It meant the fair classification. And so, but he was comparing the property to properties that were normal condition according to him. And so we also looked at his comparables, and in this particular property, both of these properties were class 242. And of the 5 comparables that the assessor used, only 4 of them were in the 242, or only one of them was in the 242 class. So 4 of them were not even in the same class as the property. So our argument was based on condition. In order to get it to normal or good condition, you'd have to, put a roof on it. The roof is 36 years old. It's a 30-year roof. The windows are original. The pool is 31 years old. The windows, the bathrooms, so to get, and he's assessing this one property at $775,774,900, and it's going to need a ton of work before it would be even remotely worth even if all those things were updated. I don't think it would be worth $774,900. It's ridiculous. But then the assessor doesn't even bother to show up to argue regarding his position on what the condition is, and that's because he couldn't argue because he's never been to the property. He just uses a computer model, and then he denies everybody, denies, and then I showed the hearing officers, both of them, that the town of Vestal, their Board of Assessment Review conducted 154 assessment cases. And they only made adjustments in 4 out of 154 to a grand total of 148,000. One of them was 15,000. Another one was like 35,000, and then one was like 5,600, and then the biggest one was 103,000, which was this truck. It was this truck repair facility that had a diner, and he's got it classified as a diner. I mean, it's just, yes, it has a diner, but it's just this. There's all kinds of tractor trailers all over the place, and they're not there for lunch. They're there to be repaired, and it's just, So the assessor says he's always right, and yet this truck repair facility is a diner, according to him. So anyway, it's very concerning that the unified court system would behave in this fashion. This is Mike Franklin, the property tax guy.